Today we're going to be dealing with civil law, the aspect under civil law contracts. Now keep in mind that under whether it's civil or criminal law, we have the overall aspect of our legal system where there might be different philosophies by the courts in interpreting laws. We might have a bedrock view, which means consistency, also more of a conservative perspective, meaning keep things the same, or a living document view, or a living doctrine view. Those with the living doctrine view say the courts are going to look at the Constitution, statutes, ordinances, regulation, and not necessarily follow the intent of the legislature, the founding fathers if it's a Constitution, but what fits best for society. So up until the 1930s, most of our judges followed what we call the bedrock view, meaning consistency, look at what the legislators intended. Then there was a movement about that time period to the living doctrine view. Today, over 80% of our federal judges interpret laws in regards to this living doctrine view. So when we talk about positive law or equity, positive law is more of the bedrock aspect. The living doctrine view is more of the equity instances. So when we think about economic issues, we kind of go back to behavior, right? Same behavior can result in what? Well, criminal law and civil actions can have the same result. We used before battery in regards to a prior lecture is the term for both criminal and civil actions. Now, if someone dies under criminal law, we might call that a murder. Let's say it's intentional in regards to the killing of another individual, and there's no exception, right? Like a SWAT team killing someone or acts of war. So murder, and then the civil side, if the relatives are suing, we call that wrongful death. Or someone stole something under criminal law, the term in Indiana is theft. We have older terms that many states use, which is larceny and embezzlement. Under criminal law, under civil law, we call that a conversion. So keep in mind what we're talking about today just deals with this aspect of civil law. We're not targeting criminal law. Now, what I want to do is look closely at chapter 12. Your author, in a statement in the second sentence in chapter 12, talks about the idea that in regards to a legal principle isn't correct. It's actually wrong. Why? Because the author is an economist, so we have to be careful about how we use and describe legal terms. The author says, I give you money, you give me an apple, there's no contract. That's incorrect. If by chance I have this particular apple and you want to buy it from me and you hand me $1 for the apple, we exchange, you get the apple, I get the $1. With that in mind, we have what we call an executed contract. Why is it an executed contract? Because it's completed. Now, within that executed contract, we could have problems. Let's imagine, in this instance, I offer to sell you the apple, you offer to give me $1 for it, but rather than this $1, you give me a counterfeit $1. Now, I tried to make this look very much like something that isn't a real $1. So with that in mind, there's fraud going on. There's also breach of contract. You give me this, and I give you the apple. Okay? So that's fraud. We had a contract, but it still was fraudulent. There's a breach of that contract. Now, let's imagine that I pull out and give you a $20 bill for the apple that only costs $1. And you don't give me back the other 19. What is that? Well, under Old English law, and many states still follow that, we call that an embezzlement. You've embezzled $19 from me. Okay? Now, in this state, meaning the state of Indiana, we call that a theft. Just a change in of terminology. It's still the same thing. Now let's change this. Let's imagine I offer to sell you this apple. You don't know there's a bite in it. You can't see the bite. So you give me the dollar for the apple. I have the dollar in my hand, then you see that there's a bite out of the apple. What is that? Again, a breach of contract, fraud. It was deceptive in regard to what was done. Okay? There still was a contract. It just wasn't, in this instance, an executed contract. Now, let's imagine I show you this apple and there's no bite in it. And I say all of the rest of the apples in this box are similar to this apple. Well, I'm using this as a representation of the apples in the box. And now you maybe will provide me a certain amount of money for that box of apples. Again, I could be breaching my contract if the apples in there aren't in as good a shape as this particular apple. I just took a bite out of it. It is delicious. Okay, with that in mind, that would again be fraud and breach of a contract. But we still have a contract. So what we want to look at are the elements of contract law. What's necessary to have a legally enforceable contract? Now keep in mind, we're talking about positive law. Why positive law? Because equity is the exception when something isn't just fair or right. Okay, so with that in mind, in front of you, you'll see a particular outline for what's necessary to have a legally enforceable contract. And we go through these particular circumstances. We say there must be an offer. So, I could offer what? Well, on page 150 in your text, it says an example of a hitman. There's an offer and an acceptance. And with offer and acceptance, that's an agreement. But with that in mind, that isn't for, if you look at number 6, a lawful purpose. So it isn't a legally enforceable contract. Okay? So with those particular types of things come into play, your chapter deals with this idea of vagueness, that something isn't definite. That's genuineness of assent. Your author on page 158 deals with a rich uncle is going to pay for college. In that instance, there's no consideration involved, but it could turn on equity. So we have particular aspects of law that come into play. So let's go through these particular principles of contract law to let you feel comfortable with what's required of a contract. Okay? But before that, what I want to ask you is what's probably the most expensive contract that an American, we won't say an international individual, we'll just try an American, might enter into? At least 50% of them, what's the most expensive contract that they might enter into? Some people will say, oh, to buy a home, to buy a car. Well, in reality, take a look at this. A marriage certificate, this is actually my marriage certificate. What I did was white it out, my name and the particular information about it, but with this in mind, if you look at it closely, it has the elements of contract law. Now, I'm going to make it large again, go down to the bottom, and it says this certificate to be filled out and given to what parties? Contracting parties at the time the marriage ceremony is performed. Now, there are technical requirements like in some contracts. This one, the state has to have a person that's authorized to enter into these ceremonies and that this form has to be back in a certain amount of time. All kinds of procedural issues that certain contracts have. And why do I say most expensive for 50% of Americans? Because it's almost 50% of Americans that do what? Divorce. So I was trying to use a little bit of humor. We have to be careful with internationals because it depends on what country they're from in regard to the particular divorce rates. But let's go back to the idea of the requirements of a legally enforceable contract, being offer, acceptance, genuineness of assent, consideration, competent parties, lawful purpose, and form required by law simply means that certain contracts have to be in writing to be legally enforceable. So if we start out with an offer, I could say to a classroom filled with students, I'll sell you this book for $10. Am I making an offer? No. Why? Because it's not specific to an individual. Okay? We call that an invitation. What? An invitation to trade, an invitation to make an offer. Okay? But an offer has to be specific to an individual. So if I hold up this textbook and I say, I will sell it to you for $20, that's specific to you. I'm making an offer. Now, you can voluntarily accept it. How might there be a problem? Well, I could say, if you don't buy this textbook from me, I will fail you in the class. Then there's no voluntary acceptance. That duress is illegal. Okay? So, back to the original, a textbook for this aspect of $20. If I hand it like this and say, would you like it for $20? And I say your name, that's an offer. How do you accept? Well, you could say yes. You could write up a contract and hand it to me. That shows your acceptance. You could simply grab it from me. So acceptance can be in writing, can be verbal, or by the conduct of the parties. Okay? Now, genuineness of assent means there's no vagueness, that both parties know what the transaction involves. So if I tell you I'll sell you my car, and you say, and I give you a particular amount, we'll stick with the $20, could be $200, right? Doesn't matter. But the idea of the car, I'm really upset with my car and I offer to sell it to you, and you say, I'll buy it. Well, I made an offer to you, I gave you a particular price, the $20 again, or $200, because I'm really upset with the car, it's having some problems. You said yes, or you write up a little contract, hand it to me, or you ask me for the keys, right? And I hand you the keys. A voluntary acceptance. The problem is there genuineness of assent? Well, what do we mean by genuineness of assent? No vagueness. And what I'm thinking I'm selling you is a Plymouth Accord, a car that the engine blew up on me 3 times. I sold it years ago, but let's imagine I still have it. The engine's missing, it's up on blocks, and I'm offering that car to you. But you've been seeing me drive around in a yellow 76 Corvette. So with that in mind, you think it's the Corvette. Well, what the courts would say is, we're not agreeing to the same thing. Now, the court doesn't say that the judge or jury has to read your mind. They just say, what would a reasonable person think was being offered, and was the acceptance for that particular thing? That's what we're looking at. If it's too vague, under contract principles, we don't have a legally enforceable contract. Now, we want to look at this idea of consideration. That doesn't mean that the individual is polite, meaning they're considerate. Consideration has 2 meanings. One, that the particular thing has economic value. And the courts, under Old English law, and we follow it still, the economic value only has to be that of a mustard seed. Well, a mustard seed isn't even worth a penny. So something worth value, but a very small amount of value is all it takes. That's under positive law. Under equity, you have to give up something you have a right to. Okay? So that's the exception. So the consideration for me selling you the book is the actual book. Your consideration is promising to provide me the $20. That's your consideration. You don't have to hand me the $20. It's just a promise to provide me the $20 is all it takes. So then we satisfy those particular terms. Now, giving up something. Let's imagine that you're 21 or older, and I tell you I'll give you a certain amount of money if you stop drinking, stop smoking. And we spell out how much money it is, because we have to have genuineness of assent, and we have to say what it is. So it's that you won't have any alcohol for 1 year from right now. I'll give you $10,000. So with that in mind, what happens is legal contract, well, there's no economic value that I'm getting from you not drinking, right? Nothing economic is going to impact me. You're not my employee. You're not my child. So with that in mind, Under positive law, we haven't satisfied the consideration, but you've given up something you have a legal right to do. You're 21 or older, you have a legal right to drink, even though you might not be drinking. That is something that you've given up. Just like lawsuits. There's a car accident, and the insurance company says, we'll give you $10,000 if you what? Promise not to sue. Or if you've already sued, dismiss the lawsuit. You've given up something that you have a legal right to do. That's what consideration is. Okay? And it has to be from both parties. And it can't be past consideration. What's past consideration? That means the activity has been satisfied by one of the parties, and then they request money or additional money. That could be like me teaching a class. The particular contract that I have says and sets out a specific amount of money that I'm going to be paid. And let's imagine I now tell Purdue that I won't finish this class unless they give me an extra $1,000. Well, I have an obligation to do these particular things, so I'm not providing any new consideration, any new value. So even if they agreed, they wouldn't have to, under the law, pay me the $1,000. Now, it's not equitable not to pay me the $1,000, but the court wouldn't enforce it under equity. Why? Because I have a legally enforceable contract, and I have to abide by that. I have to follow that contract. Okay. So what do we mean by competent parties? Well, that deals with the aspect of a minor, a person that's intoxicated, or a person that isn't mentally stable. So could be a person that has extreme dementia, Alzheimer's, or a person that the court has provided a guardian for the individual. Okay? Not a competent party. So the easy example to start with is the minor. Okay? We're not talking about farmers, and we're not talking about minors in regards to coal miners or copper miners, but children. Someone under the age of what? 18. So if they're 18 or older, they're no longer children, they're no longer incompetent individuals. So I'll use the example I've used before, my 16-year-old son. Let's imagine I send him to the levee to pick up a game. Well, that isn't going to work because he's now being my agent, and even if he isn't of the right age, I'm liable because I'm the party really entering into the transaction. He's only doing it on my behalf. So let's change that example. Let's imagine that he goes down to the levee to GameStop, whatever the particular video place is, and he buys a game. Now, he's not supposed to be able to buy a mature game because he's not old enough. There's laws against that. That's the number 7 here. But he buys a particular game that's $60, and then there's tax added to that. Well, he's an incompetent party. So what happens is at any time before he turns 18, he can return that, and they're supposed to, under the law, give him his money back. Okay? The only exception is if it's a necessity of life. What's a necessity of life? Food, shelter, medical care, education. Now, my son would think that this video game is a necessity of life, but the court wouldn't. So, not a necessity of life. If he goes somewhere for lunch and he pays, eats the lunch, that's a necessity of life. Unless it's way more expensive than my particular standard of living normally would be involved. So he's having caviar and all kinds of expensive foods. Then we look at an equity issue. Okay. Now, the idea of competent parties, it's still a legally enforceable contract, except the minor or their guardian can get out of that contract as long as it is a necessity of life. If it's a necessity of life, the idea of food, shelter, health care, education, it has to be reasonable under equity in regards to the cost. So the courts will reduce the cost if the party's trying to take advantage of the minor. So it is a legally enforceable contract. The business person can't get out of the contract, meaning he orders it and then they say it isn't available and it costs him $80 someplace else. He's now been damaged $20 plus any increase in tax amounts, and the business is liable for his damages. Now, they can't just tell him that, oh, I'm sorry, We're not going to sell it to you, even though they've agreed to him, they've taken his money, let's say, for that particular game. That's a breach. He can get out of the contract because he's the incompetent, they can't. So let's try the alcohol situation. Let's imagine someone's intoxicated. Well, it depends. If a reasonable person would know they're intoxicated, they have a right to get out of that contract within a reasonable time upon becoming competent, meaning no longer intoxicated. If the party that they contracted with had no idea, and a reasonable person wouldn't have any idea that they were intoxicated, then it's a binding contract between both parties. So let's try this example. Let's imagine my hypothetical that a faculty member or professor goes out drinking with you and a few other students. And with that in mind, the particular professor, and I'll use myself as an example, let's imagine that I've had too much to drink. Why? Because I don't normally drink, so just a few beers or whatever it is that I drink makes me intoxicated. And now I say, oh, if you'll buy another pitcher for me, you can have my Corvette. It's the yellow one sitting out on the street. And I hand you the keys, and you buy the next pitcher of beer. Well, if I wasn't intoxicated, that would be a legally enforceable contract. It satisfies all the necessary terms. I'm intoxicated, it's still a legally enforceable contract, but I have the right to get out of that contract. So you buy the car from me for the cost of a pitcher of beer, and now one of the other students that are at the table with us, they take me home. Why? Because I don't have a car and because I'm intoxicated. And with that in mind, the next afternoon, I wake up, I go out to the garage to get in my car, and I can't find it. And I go, Lori, where's my car? And her response, Lori's my wife, she says, did you lose it again? I'm thinking, oh, no, I can't remember what happened to it. So I start talking with individuals that were with me at the bar, not you, but I find one or two of the other individuals, and they tell me the story of how I traded my car for a pitcher of beer. Well, I have a reasonable time upon becoming competent. Now I'm competent. I have a reasonable time to contact you and let you know what? That I want my car back and I reimburse you for the cost of that pitcher of beer. If I do that, you're supposed to provide me my car back. If you don't, I can sue, and the court will require either the car be returned, or if you've sold it, the reasonable value of that car. So the idea of competent parties. Same thing with someone that has dementia. My father has dementia when he's in the final stages now, but before he was to the final stages, we moved him into a home 3 doors down from us, and we would see him 7 to 10 times a day trying to take care of him, but he still would walk around, and that was fine. He didn't get lost. But let's imagine that he wanders onto a new car lot, and at this particular point in his life, he really liked cars and trucks again. He actually would have toys in his home that he never had before, but the dementia is causing him to regress to a younger mental age, basically. So with that in mind, the salesperson sells him a brand new truck. Well, if he's not competent, they probably will take advantage of him, meaning sell it to him for much more than sticker price, especially if the salesperson is on commission. So with that in mind, he has a reasonable time through his guardian, myself, so I have a reasonable time to what? Get out of that contract. Unless we want him to have it, unless he got a great deal on it and we wanted him to keep the truck. Okay? So the contracts are legally enforceable with the incompetent person having the right to get out of that particular contract. Now keep in mind, all of this dealing with contracts involves civil law, not criminal law at this particular point in time. Okay? So, lawful purpose. As your textbook used the example of a hitman, that's not for a lawful purpose. Okay? Or a 19-year-old asking someone that's 21 or older to buy him alcohol. That's not a lawful purpose. So, if it's not for a lawful purpose, then under positive law, the court says we leave you where we find you. If there's an equity reason in certain circumstances, then the court might require the parties to be put back in the original position that they were in. So let's imagine I hire a hitman to kill me. Now that doesn't sound logical, but I don't want to hire a hitman to kill someone else, but I'm too much of a coward to kill myself, and let's imagine I have lots of insurance on myself, and I want my family to get those monies, and if I kill myself, that's a suicide. It'll be excluded under insurance, meaning the insurance won't pay, so I hire a hitman to kill me. With that in mind, the hitman gets how much money? Well, depends on what I can negotiate for, but am I going to give him all the money up front? Or her all the money up front? Probably not. What am I going to do? I'm going to give them half the money up front and the other half upon completion of the task. So let's imagine I tell them they have to kill me within the next week. And they don't. Meaning they're just going to keep half of this $5, the $250, or the $10, or the $10,000, or the $50,000, and they're not going to carry through with the hit. Okay. So what do? I sue them to get half the money back. So if I go to court, will the court enforce this contract? No. Why? Well, even if we had all of the other elements, it's not for a lawful purpose. So the court will say, we leave you where we find you. The hitman gets to keep their half, but I can't get it back. Now, that brings us into criminal law, which we're not covering right now. We're going to cover in future chapters. So the court could enforce something in regards to criminal law. Now, remember I said the person that isn't 21 asks an individual that's 21 or older to buy them beer. So let's imagine they ask me. Why? Because I'm an old man, and they think an old man maybe will provide the alcohol for them. So I ask them what kind of alcohol, how much, and I want at least $5 in it for me, so they give me $20, and I'm supposed to buy them, I don't know, a certain amount of beer. And I go walk into the front door of Walmart, and they're waiting out front. I come out a side door, go to my car, and leave. Okay? Well, if it was a legally enforceable contract, we'd say I breached the contract. But it isn't a legally enforceable contract. Why? It's not for a lawful purpose. The court under civil law would let me keep the $20. Now they might find me and beat me up. That's criminal. Or even offering to get it for them is illegal to do. But that's criminal law. We're dealing right now with civil law in regards to contract matters. And the court will say, we leave you where we find you. If there was an equitable reason, meaning it wasn't just fair or right, the court would use equity and require me to give them back the money. But they don't want to encourage these students or this individual to go to someone else to try to get alcohol with the $20. Now, form required by law, that's the aspect that certain contracts have to be what? In writing to be legally enforceable. So with that in mind, I want you to take a look at this. Under the statute of frauds, what's the statute of frauds? Well, it follows laws from Parliament 400 and some years ago. The same principles that they use requiring certain contracts to be in writing. Now, under our system, like in Indiana, we have certain contracts like an individual that's remodeling a home. That has to be in writing. That doesn't fall under statute of frauds. It's a separate area. Intangibles like stocks, bonds, insurance has to be in writing to be legally enforceable. So we have many other areas that have to be in writing. This idea of statute of frauds simply gives what all 49 of the 50 states have agreed to, right? Because each state is a separate sovereign. We have 50 states. Each state, unless it conflicts with federal law, has the right to create their own laws, to enforce those laws. It's just like the EU with the 28 countries. Each one is a separate country, and then the European Union pulls them together. Well, they can do whatever they want as long as it doesn't conflict with those treaties. Same idea with the United States. Unless it conflicts with federal law, the states can do pretty much whatever they want. Well, in order to make business practices similar, we have this aspect of the statute of frauds. 49 of the 50 states have agreed to these terms. Louisiana, which doesn't follow English law, follows Napoleonic law, meaning French law, and their basic ideas, doesn't follow it. So we have the sale of goods, $500 or more. We have a few states that have increased this to $5,000. Most are still at the $500 amount that was put in place and agreed to in the 1950s. So inflation, it should be at least $5,000, but Indiana is still one of the states that follows the $500 amount. So with that in mind, the sale of goods, $500 or more, has to be in writing to be legally enforceable, unless the contract's executed, meaning you get the thing and you've provided the money. If the conditions haven't been satisfied, then the statute of fraud comes into play. Fraud just means deception, misleading. So we have certain contracts that need to be in writing. So what's a good? Well, a pencil, a pen, clothing, jewelry, all of those are goods. This doesn't deal with sales of what? Services. So what I'm providing right now is a service. It doesn't fall under this $500 amount. Or if I'm leasing an apartment, that doesn't fall under the monetary amount. But many states will say leasing commercial property will have a separate statute that's in many states requires that to be in writing. But many states will say if you're renting an apartment or a home, it doesn't have to be in writing unless, that's the next item, unless it's more than a year in time. So if you contract to rent an apartment and you contract today to have the particular rental start the beginning of the month and go for a year, well, today is a number of days before the beginning of the month, so that's more than a year in time that you're contracting for. It isn't the time period when the contract ends only, it's from when it starts, and you contracted today verbally to have it end, then it has to be in writing to be legally enforceable because it's more than a year in time. So services also. If Purdue asks me to teach a class on a legal principle 2 years from now, and they don't send me an email and I don't respond in writing, because an email is a writing also, or they don't sign a contract with me, that's not legally enforceable. Why? Because it's more than a year in time and it isn't in writing. Okay? Another aspect from Old English law is this idea of the sale of land. Has to be in writing. Why? Well, because it's so significant. Use an example where I grew up on the farm. So let's imagine that I own a farm and I want to buy my neighbor's farm, and I've been trying to buy it for 20 years and he won't sell it to me. So what do? I get all my relatives together and I have them commit fraud. Catch it? Statute, act, code means the same thing. I have them agree to say in court that all of us were together on a particular date at a particular location, and you heard this neighbor agree to sell me his particular farm, certain number of acres, the buildings, all the crops, everything for a certain dollar amount, okay, that it was agreed to, but there's no writing. Well, if this wasn't required to be in writing, who would the court believe? Me and all of my relatives, 30 relatives. They're coming to say they heard the other rancher or farmer agree to sell their property. The idea behind that is we don't want this fraud to go on. So it has to be in writing to be legally enforceable. Then we move to something like the promise to pay the debt of another. That's the same as a cosigner. What do we mean by cosigner? Well, just an individual that isn't getting anything out of agreeing to be responsible for someone's debt. So I'm a cosigner on my oldest son's credit card. So if he doesn't pay his credit charges up to the dollar amount that I agreed to, then what happens is I become liable for his debt. You might have that where a parent agrees to be a cosigner not just on credit cards, but on a car or to buy a home, or maybe even to rent a building or a loan from a financial institution. Okay? Promise to pay the debt of another. It can't be verbal. To be enforceable, has to be in writing. Now, promise to personally be liable for the debts of an estate. Well, we don't have that too much anymore, but let's imagine my father that has dementia dies. Okay? Now, if he has lots of debts and I'm the executor of his estate, the person that pays out of his estate, I don't have any personal liability for his bills. But if I put in writing to one of his creditors that even if his estate, meaning his assets, don't have enough to pay, that I'll be personally liable, then I am. If I verbally say it, it doesn't legally bind me. Ethically, it binds me, but not legally. So under the law, I'm not responsible. How about promises in consideration of marriage? That's a dowry. That's what we mean. And that's the Old English law aspect. Under Old English law, what happened was the family of the woman had to give the man property, whether it was land, cattle, oxen, to have this marriage go through. Now, if we move back to antiquity, in most countries it was the opposite. The male had to provide to the family of the female equity, assets to be able to marry the particular female. So laws change over time because of cultural changes. Today, do we have promises in consideration of marriage? Yes, we do. What are they? Well, the family of the woman, what do they normally pay for? It isn't required under the law, but the culture is that the family of the woman will pay for the cost of the wedding. They don't legally have to, unless what? Unless it's put in writing. Okay, so what does the man's family pay for? Well, legally, nothing are they responsible for, but culturally, what are they responsible for? The reception. The rehearsal dinner usually is what it is, but they aren't legally obligated unless what? Unless it's put in writing. Then they're obligated. Now keep in mind, under contract law, it has to be what? Well, we have to have the offer, the acceptance, genuineness of assent, the consideration, competent parties, lawful purpose. If it's more than a year in the future, it has to be in writing. Okay, and in this instance, because it deals with promises and consideration of marriage, it has to be in writing. But consideration, what they're going to provide, how much money, that deals with genuineness of assent. You have to get down either that they'll pay for certain things or that they'll pay a certain dollar amount. Now, here's the problem. Let's imagine that the parents, whether it's the bride or the grooms, end up not being willing to pay those costs. Yeah, just the way you want to start a marriage, suing your in-laws, right? Okay, well, that's the end of this portion of contract law.